Good morning. How are you doing today?
I'm a little overwhelmed, but I think you might be able to help me out. CPS removed my granddaughter Lucy from her home and placed her with me. The social worker told me to go to court to get a guardianship, or she would have to take the matter to court. I went to the courthouse, and they gave me this big stack of papers. I'm not sure where to begin.
That happens a lot. The packet is a little intimidating, but it does have all of the forms that you need to ask for guardianship of the person. Had you heard of a guardianship before?
Isn't it when you get custody of a child?
Something like that. It's when the court orders that someone other than a child's parents have custody of a child or the ability to manage the child's property, or both. Most people are looking for a guardianship of the person because most children don't have property or other assets that need to be managed, although this sometimes happens, especially when parents have passed away leaving an inheritance.
Oh, there's no money or anything like that. I just need custody.
Great. We'll work on the paperwork for a guardianship of the person only then. Before we get started with the paperwork, have you had the opportunity to do any research about the steps you need to take to obtain a guardianship?
Not really. Could you go over it?
Sure. The process starts with filling out the forms, which is what we are working on today. Once they are completed, you would make copies and file the originals and the copies at the probate court. The court will assign a hearing date for your case. It's up to you to then have the petition and a notice of hearing served on the parents, grandparents, the child if 12 or older, as well as any siblings who are 12 or older. If any of these relatives can't be located, you would need to complete a form explaining all of the steps you took to locate them and ask the court to excuse you from giving them notice of the proceedings. About 2 weeks before your hearing, the court will publish what they call probate notes, which identify what, if anything, is missing from the file. You would then do a written response to those probate notes, and finally, you would attend your hearing. Hopefully, at the hearing, your guardianship will be granted. This whole process takes about 2 months from start to finish.
That long?
By court standards, that's pretty short.
So, since Lucy doesn't have any assets that need management, I'm looking at a guardianship of the person. How is that different from an adoption?
I get asked that a lot. The biggest difference is that adoption is permanent. If you adopt Lucy, you become her parent for life. Her parents' rights would be terminated, and they would no longer legally be her parents. Guardianship is temporary, and at most would only last until Lucy turns 18. During the guardianship, her parents' rights would be suspended only, not terminated.
Other than Lucy turning 18, how else could it end?
Other than ending automatically when Lucy turns 18, a guardianship would end if someone asks the court to end the guardianship and the court grants the request. It could also end if Lucy successfully petitions the court for emancipation, joins the military, or gets married before 18, but those last three are fairly uncommon.
You said the guardianship would grant me custody. What does that mean?
Lucy would live with you unless the court orders differently. You would be responsible for feeding her, clothing her, making sure she goes to school and gets necessary medical treatment, counseling, and so on, just like a parent. You would be responsible for making her health care decisions and education decisions, just like a parent. You'd also be liable for any intentional acts that she commits, such as vandalism, and if you get her a driver's license, for any motor vehicle accidents, just like a parent would.
What if I want to move?
You'd need to notify the court in writing if you move somewhere else in California, but you'd need to ask for a court order allowing the move if you wanted to move outside of California.
Okay, so unless the court says differently, Lucy would need to live with me. Could she spend a weekend at a friend's house or go on a camping trip?
Of course, she must live with you, but that doesn't mean that she can't have sleepovers or go camping or things like that.
What about her parents? I know her father still wants to see her.
Parents are presumed to have a right to what the court calls reasonable visitation, but the guardian gets to decide initially what that is.
Can I be guardian with my husband?
Of course, you can both ask to be guardian.
Do I have to apply with him to be guardian?
Of course not. You should decide together whether only you or both of you should be guardian. If you're both guardian, you're both responsible. On the other hand, if something were to happen to either of you, the other would still have the power of a guardian.
I'll think about it and talk it over with him tonight. I think I'm ready to tackle this packet. How long did you say it takes to get guardianship again?
About 2 months.
That's too long. I need to get Lucy enrolled in school and take her to the doctor so I can get her enrolled. Can I get something before the 2 months?
If there was an emergency, like a danger to Lucy's safety, you could ask the court for a temporary guardianship to last until the hearing on your guardianship, but for a doctor's visit or school enrollment, you probably only need the caregiver's authorization affidavit.
I think I saw that in the court's form packet. That's the first form with blanks to fill in the court's packet, right? How am I going to get the parents to sign this?
You're correct. That is the first form in the packet, but it doesn't need to be signed by the parents. The caregiver's authorization affidavit is a declaration in which you state that you're Lucy's relative, you're caring for Lucy, and that you've notified the parent of your intentions or could not find her parents. It's then signed under penalty of perjury by you, not the parents.
And this will allow me to enroll Lucy in school?
Probably. Doctors may rely on this form to get authorization to perform treatment, and schools may rely on this to establish residency in the school district.
Can I use it to add Lucy onto my insurance?
Probably not. Insurance policies, benefits, and numerous other things will probably require guardianship. The caregiver's authorization affidavit isn't a court order and could be revoked by the parents at any time.
Well, I will need one of these. Where do I file it?
The caregiver's authorization affidavit is not filed with the court. You present an original to any doctor or school that needs it. Oftentimes, hospitals will carry their own version of this document. In any event, having one on hand never hurts, and you may end up needing several, so be sure to keep an extra copy on hand. Since it's likely you'll need this, let's fill this out. What is Lucy's full name?
Lucy Dawn Johnson.
That's D-A-W-N?
Yes.
The form itself is pretty self-explanatory. I'm just writing Lucy's name onto line 1 where it says name of minor. And what is Lucy's birth date?
July 17, 2014.
Okay, I'm typing that onto line 2. Then your name on line 3. What is your address?
321 Pinewood Circle, Sacramento, California, 95814.
I'll go ahead and fill that in on line 4. I'm checking the box on line 5 to indicate that you're a qualified relative since you're a grandparent.
What's a qualified relative?
As it says on the second page of the affidavit, A qualified relative in this case is a spouse, parent, step-parent, brother, sister, step-brother, step-sister, half-brother, half-sister, uncle, aunt, niece, nephew, first cousin, or any of these with the word great or grand in front of them, as well as the spouse of any of these, even if the marriage ended with divorce or death of the biological relative. As you can see, it's a broad category.
Spouse, I can't see how that would apply.
It's because any of these relatives may marry, and even the minor may be married, because in California it's possible, but very rare, for a minor to be married due to the hurdles that need to be overcome. Have you told the parents or anyone else with legal custody that you intend to enroll Lucy in your local school?
I told her father, and he's okay with it. I haven't been able to locate her mother.
That's fine. I'll go ahead and check the first box in line 6 indicating that you consulted with them and he didn't object. The second box would be used if you couldn't find either parent. For lines 7 and 8, let's go ahead and get the date of birth and driver's license or California identification card number. I'll go ahead and print this out. Don't forget, the caregiver's authorization affidavit isn't filed with the court. You'll sign a new one for any doctor or school, and they may have their own.
Is the rest of the packet this easy?
So-so. Depends on the form, but not so much harder. Just tedious.
I'm ready for the next form.
Since you are doing a guardianship of the person only, the court's Part 1 packet contains a version of the petition that is specific to guardianship of the person. The form number is in the upper right, CG210P. Up at the top where it says Guardianship of the Person of all children's names, I'm writing out Lucy's name. If you were seeking guardianship of more than one child, you'd list the others as well, but since it's just her, it's only her name.
Item 1. Your name. That's me, right?
Exactly. I'm writing your name in paragraph 1 on line A. If someone else were petitioning with you to be co-guardian, we could use the other lines. And let me just finish typing in your address and telephone number in paragraph 2.
I don't have an attorney, so what goes in paragraph 3?
If you are representing yourself, it's just left blank. If you were represented by an attorney, he or she would fill out this information. In paragraph 4, I'm checking the first box to indicate that you are asking to be guardian and then skipping to the next page.
Didn't you forget the name and address at the bottom?
Although a lot of people are drawn to that, it's not necessary if the petitioner, that's you in this case, is the person asking to be guardian. Your contact information has already been listed above, so it's not necessary to list here.
Then why have it there?
It's because it's possible that someone other than the potential guardian might ask the court to appoint a guardian.
Like who?
The parents, for one. In some instances, a parent petitions the court to appoint a guardian. Also, a child 12 or older may petition to have a guardian appointed. Moving on to the next page, at the very top of the page, I'm typing Lucy's name again where it says Guardianship of the Person of all children's names. Many forms involved in this, requesting guardianship, have a spot to write the children's names. This allows the clerk to determine which case a page belongs to in the event that it becomes misplaced.
In item 5, the first box is checked since I'm Lucy's grandmother, right?
Exactly. If you weren't related, you'd check B, and if you had a signed nomination form from the parent, you'd also check 6. A guardian doesn't have to be related to a child. If you're related, your home visit is done by a probate investigator. If you're not related, it's conducted by a CPS liaison. Since you're related, I'm skipping over paragraph 6. I'd only check that one if I had checked that you weren't related in item 5, and would then answer the questions in parts A, B, and C to answer whether you ran a licensed foster home and whether or not you, the petitioner, were the proposed guardian.
Once you get going, this form doesn't seem that bad. What does 7 mean?
7 is only checked if the parents have nominated someone else in writing to be guardian. Usually this is on the nomination of guardian form or a will. In paragraph 8, I'm just copying Lucy's full name and the birth date onto line A. The rest of the lines would only apply if you were seeking guardianship of more than one child. The checkbox at the bottom would be used if you were seeking guardianship of more than 5 children. In that case, a box would be checked and an additional page labeled as Attachment 8 would be attached with the names and dates of birth of the additional children.
The top of page 3 looks familiar.
Indeed it does. Let me just type it in. This next section, paragraph 9, is one of the hardest parts of the petition to complete. This is asking why Lucy needs the court to appoint a guardian.
Well, her father was arrested and is in jail, and her mother hasn't been caring for her because she's an addict. There was this time in 2014 when her mother... And then she screamed that she wanted more bread and snuck out of... Which is why she shouldn't care for Lucy.
That would explain it. Just remember that you have two different audiences that will be reading this document. The first is the court, and the second is Lucy's parents, grandparents, and any of Lucy's siblings that are 12 or older, and Lucy herself if she were 12 or older. You need to both be clear enough that the judge, who doesn't know anything about Lucy or her situation yet, can understand, but try to do so in a way that it doesn't cause unnecessary family conflict. You need to show that the parents can't or won't care for her, or that the arrangement is mutually convenient for everyone, but it isn't necessary to detail every bad thing that a parent or existing guardian has done.
You've just heard my story. How would something like that be summarized?
Let me see. How about this? Although Lucy's mother loves her very much, she has been struggling with addiction for the past 4 years. Although she has sought help on several occasions, she has been unable to remain sober. This addiction has caused her to become homeless. Lucy's father was recently placed in jail and is expected to be transferred to prison later this year. Because neither parent is currently able to care for her, the petitioner has been caring for Lucy for the past 5 months.
That looks great, although I may modify it later on. Any recommendations?
Whenever writing a long answer like this, it is often helpful to write a first draft on a separate sheet of paper or on a separate document. Have a friend or family member you trust read it and explain it back to you to know that it is clear. If he or she hesitates or gets it wrong, rewrite it.
Got it. What is 10B for?
If there are relatives that would need to be served that you already know can't be served, you would explain briefly and identify them. For example, you previously mentioned that Lucy's grandfather, your first husband, died last year. In 10B, I am writing his name and indicating that he cannot be served because he is deceased. If you need more space, you can check the box and create a page that says Attachment 10B at the top to continue. Moving on to paragraph 11, I know you will be filing a confidential guardian screening form GC212, so it's probably safe to check that box. The remaining boxes will depend on whether you are seeking a temporary guardianship pending the hearing or have a written nomination of guardian form. You'll want to come back to this box when you've finished all your papers. Do the same thing for paragraph 12. There is a line to write the number of pages, but wait until you complete all copies of this next form before writing this number.
Will it matter where I sign?
A little. Skip over the first signature line, the one that is by itself and says Petitioner's Attorney, types or prints name here under it. Instead, date, print your name, and sign on one of the bottom 3 lines. If your husband were asking to be guardian as well, he would sign one of the lines.
2 down. What's next?
Form GC210CA, the Guardianship Petition Child Information Attachment.
Okay, this has all children's name again at the top, and then this child's name. So I'm assuming we're going to write Lucy's name twice?
Exactly. The reason the form does that is that one of these forms is filled out for each child in a guardianship case. The top part identifies the case that it is a part of, and then which child the attachment is about.
I think I get this. Since the first form we filled out was form CG210P, I think you're going to check the second box at the top that says Item 8 of form CG210P, and then check Person on the line below that.
That's correct. In section 1, on subsection A, I'm printing Lucy's name and birth date, and then, on line B, her address, which is yours, since she's living with you.
I'm looking at Part C. Why do they want to know if Lucy is a member of or eligible for membership in an Indian tribe?
It's because of the Indian Child Welfare Act. Prior to the passage of the Indian Child Welfare Act in 1978, approximately 25 to 35% of children in custody proceedings involving Native American children resulted in them being placed into non-Native American homes, often resulting in a loss of their culture. The Indian Child Welfare Act requires that a native child's tribe or potential tribe to receive notice of the proceedings if he or she is involved in a custody proceeding. This allows the tribe to have a say in the proceeding and to ensure that the child's heritage is protected.
That makes sense. I already know that she has no ancestry on my side of the family. But how am I supposed to find out whether Lucy has any Native American ancestry on the other side? Where should I start?
If Lucy had been old enough, a good first step would have been to ask her if she knows of anyone in her family who is part of a Native American tribe, or if there are any stories that she knows of in the family. Now, you said you already know about her father's side of the family. What do you know about the mother's side of the family?
I don't know anything, so I'll call up her other grandmother to see if she knows anything. Since I've never heard anything, I doubt there's any ancestry, but I'll check anyway.
Since you're pretty sure, I'll complete this as if you've already made your inquiry and found no ancestry, but do your inquiry and change the response to this before you file if you discover any possible Native American ancestry. If I remember correctly, Lucy's 2 right now, so is it safe to assume she's never been married?
Of course.
In that case, I'll check the Never Married box in 1D.
I think I know how the top of the next page is going to look.
I'm pretty sure you do too. Let me go ahead and fill this in. Do you know if Lucy is receiving any type of public assistance?
I think she's receiving food stamps, but I don't know the amount.
So I'll go ahead and indicate yes in paragraph 1E and indicate other that she is receiving SNAP, but the amount is not known. If you learn that the situation is different or you learn any specifics, you change this section before you file.
In 1F, don't I have legal custody of Lucy? She's living with me.
Legal custody is decision-making power. It is typically going to be one or both of the parents, unless the court has ordered that someone else has legal decision-making power for the child. Were there any other cases involving custody of Lucy?
No.
Okay, I'll go ahead and enter in the name and address of her parents.
So, since Lucy is living with me, would I be the person listed in 1G?
You would. Let me just fill that in. I assume Lucy isn't on leave from a state institution, right?
No.
Since Lucy isn't in or on leave from an institution, I'm skipping over 1I. Starting at the bottom of the page, in section 2, in number 2, the names and addresses of each of Lucy's parents and grandparents need to be listed.
I've got the information written down here so you can copy it.
Thanks. Let me just go ahead and type this in. I noticed that you didn't write an address for Lucy's mother. Do you have any information about this?
Lucy's mother is homeless. For a while she was couch surfing with friends in Sacramento, but more recently she's been out on the streets. I've been unable to find her.
I'll go ahead and write unknown for right now. You still need to search for her and complete a declaration of diligent search and request to dispense with notice form to ask the court to excuse you from needing to have her served in the event that you can't find her. I'm not writing NA because that means not applicable. The names and addresses are always applicable, but sometimes you just don't know the answer. Also, since her grandfather on her father's side passed away a few years ago, for the address I'm writing deceased.
In this next section, it asks about Lucy's brothers and sisters. She doesn't have any brothers and sisters, but her mother had 3 other children with a different father.
So they're half-brothers and half-sisters?
I guess so.
Half-brothers and half-sisters count, so they will all be listed. Since these brothers and sisters are entitled to be served with a copy of the petition if they're 12 or older, you can help the file examiner out a little bit by writing out the brother or sister's age in parentheses behind their name. For example, I see from your note that this sister's age is 8, so you can write out age 8 in parentheses. This will let the file examiner know she doesn't need to be served.
Since I'm only asking for guardianship of the person, and no one else has been nominated as guardian by the parents, it looks like I'm ready to move on to section 3. That's easy enough. Let me write down my name and how I am related, paternal grandmother. Okay, number 4. Explain why appointing the person in 3 guardian would be best for this child. Didn't I already explain why a guardian is needed?
You did. On the petition, you explained why a guardianship was needed. Here they want you to explain why appointing you to be guardian would be the best choice.
So I can explain that Lucy has been living with me on and off her entire life, and I make sure she gets to her doctor's appointments and sports on the weekend?
Exactly. Whatever it is that makes you the best choice for guardian. Just like before, remember your target audience and do not be afraid to write a draft or two before you copy it onto the form.
I think I have it.
Great. Once it's copied over, we'll move on.
The next question, do one or both of this child's parents agree that the person in 3 can be the child's guardian? Well, my son, her father, has spoken to me and asked that I be her guardian, so yes for Section A. Her mother is homeless, and I haven't been able to ask her, so that would be not known at this time. I think I got that.
And of course, if either of them had said they don't want you as guardian, no would have been checked for that parent.
Item 6. Does this child live with the person in 3 now? Yes, Lucy lives with me. If the court approves the guardianship, will this child live with the person in 3? Of course she will. Does the person in 3 plan to adopt this child? No.
Sometimes people who are adopting a child get guardianship first because getting a guardianship is a lot faster.
Makes sense.
Finally, you can skip over paragraph 7 because you are the person seeking guardianship. Paragraph 7 exists in case the petitioner is the parent, child, existing guardian, or other person petitioning for appointment of guardian, and would have been used to identify how you were involved in the case.
Paragraph 8 is long.
This paragraph deals with whether the child is Native American or could be considered a Native American child. This is important under the Indian Child Welfare Act. I'll leave checkbox A blank since this is a guardianship of the person, not a guardianship of the estate only. I'll also skip checkbox B and the numbered boxes below them since 1 under it would only be used if you already knew Lucy is a Native American child, was already identified by a tribe. 2 is only used if you are the child's Indian custodian, and 3 is used only if you have been unable to contact any relatives or Indian custodian to do an inquiry with an explanation as to why you could not contact them. Instead, we'll check box C. You should contact the other grandparents or anyone else who might have knowledge as to whether or not your granddaughter has Native American ancestry, and then write Form GC210P, Lucy's name at the top, and attachment 8C1 at the top of another page, and write the name, address, and telephone number of anyone that you contacted and the date that you contacted that person. Then you'd attach that page onto this packet. Based on the information you receive, you would indicate whether Lucy is or may be eligible for membership in a tribe, whether Lucy's parents, grandparents, or great-grandparents were members of a tribe, whether Lucy's parents, or her Indian custodian live in a predominantly Indian community, and whether Lucy or Lucy's family has received any services or benefits from a tribe that were only available to members of a tribe. Checkbox 6 would indicate that you believe that she may have some Native American ancestry, while 7 allows you to state any other reasons you believe that she might have ancestry.
And 8 is used to say that she has no known ancestry. I'm pretty sure it'll be 8 because I don't know of any, but I'll double check with the other grandparents. I'm guessing by the size of the packet, but we're not done yet.
No, this was just the first form. Be thankful that you're only seeking guardianship of Lucy. If you had more grandchildren you needed guardianship of, you'd fill out a copy of the attachment for each child.
It looks like the next form in the packet is called Duties of Guardian.
This form is very easy. It explains to people what they are required to do as guardian. A lot of it deals with guardians of the estate, but some of it talks about guardians in general, and some about guardians of the person. The top of the first page looks pretty much like the top of the civil case cover sheet. You'll complete this with the same name, address, and telephone number that you used on the first page, the civil case cover sheet, and where it says Attorney for, once again write in pro per. Anytime you see a caption box like that, it will be filled out exactly the same way. If you're filling this out with the spouse, both of your names would be up there. And of course, in the box it says guardianship of the, I'll go ahead and check person, and then write in Lucy's name. Give me just one moment.
Okay, then on to the next page. There's nothing to fill out.
No, just a spot to write Lucy's name at the top of each page. The only other thing to do on this form is to date, print your name, and sign on the 5th page of this form to state that you've received a copy of it.
Why even have this form?
The court wants to make sure that anyone who is appointed guardian knows what's expected of them, so this form tells them. By signing it, you are telling the court that you've received a copy. You should read the parts that deal with guardianships of the person and guardianships in general to know what you're expected to do.
The confidential guardian screening form is next. It has a top caption, just like the last form, which I assume will be filled out the same way. After that, checkbox to indicate it is a guardianship of the person, and a space to write Lucy's name.
Exactly. The caption is the same. The information on this form is about the proposed guardian, you in this case. On to paragraph 1. Proposed guardian. That's your name, date of birth, social security number, driver's license number, and telephone numbers. I'll just copy that over. Easy enough.
What if I don't have a work number?
I'm just writing none in the spot where it would normally go. This lets the file examiner know that you didn't just skip over the question. Note that I'm not putting NA, which stands for not applicable, as an answer to any of these, because they are applicable, you just don't happen to have a number.
What if I decide with my husband that we should both ask to be guardians? There was only one spot to write the name, date of birth, and so on.
Each proposed guardian must complete their own confidential guardian screening form. This form is about you. Your spouse would complete a separate form. In the next section, items 2 through 19 are a series of checkboxes that, when checked, form a sentence. To each, you would check the box that makes the truthful sentence. So, for example, the first one says either I am or I am not required to register as a sex offender under California Penal Code Section 290.
No, I don't have to.
So the I am not box is checked. If for any reason you have to check the yes, I have, or I am boxes, you would need to attach an explanation so that the court can consider why it shouldn't disqualify you from being a guardian.
That's easy enough. Okay, the next one. I have or I have not been charged with, arrested for, or convicted of a crime deemed to be a felony or a misdemeanor. I was arrested once when I was 19. There were never any charges filed. That was so long ago. Do I need to list it?
Yeah, unfortunately you do. This question catches a lot of people because there's no time limit, and it includes arrests and charges, not just convictions. So what did you get arrested for?
I was out with some friends in Indiana. Back then you were allowed to drink a low-alcohol beer before turning 21. So after a few of them, I was a little buzzed, which wasn't the problem. I just had to pee really badly. We were a long way from anywhere with a bathroom, so I just hiked up my skirt and went in the gutter. Cop was walking by at the time and asked me what I was doing. I recall making a rather rude comment about his mother, at which point I ended up in the back of his patrol car and was taken downtown where I was booked for indecent exposure, public drunkenness, resisting arrest, and destruction of state property.
Destruction of state property?
He claimed I ruined his shoes when he stepped off the curb into the puddle.
Okay, remind me not to ask you about this again.
In any event, the DA decided not to prosecute.
I didn't realize what a rebel you were.
Just young and stupid, or maybe drunk, or both.
In addition to checking I have, you would also check the second box in the paragraph to indicate that you were arrested for a drug or alcohol-related offense, in this case, public drunkenness.
It sounds so bad on this form.
That's why you get a chance to explain. If you have to check yes, I have, or I am in any of these statements, you would attach an additional page and label it attachment followed by the number of the question, in this case attachment 3, and then write your explanation of what happened and why things are different now. So in your case, we'll just summarize what you just told me. Was that your only arrest?
Yes.
Then it's probably worth mentioning that you've reformed your wicked ways.
Now you're just making fun of me.
Okay, maybe a little. Since this is going to be read by the court before ever talking to you, we'll want to be sure to use complete sentences in any attachment and write it in a way that a complete stranger who doesn't know you can understand. When writing, it's often good to write it first on a piece of scratch paper and then copy it onto your attachment when you are happy with it.
Let's see. 4. I have not had a restraining order filed against me in the last 10 years. 5. I am receiving services from a psychiatrist, psychologist, or therapist for a mental health-related issue.
What's going on?
Since my oldest child, Jesus, died in a car crash last year, I've been seeing a therapist to help with the depression. It's really good that I've been seeing her, since I'm not sure I would have been ready to tackle this guardianship if I hadn't.
So an attachment for this one needs to be written as well. As you see, your explanation is very simple, and the court would much rather see someone with a treated mental health issue rather than an untreated one.
6. Do I or any other person living in my home have a social worker, parole, or probation officer assigned to him or her? No. 7. Have you or has any other person living in your home been charged with, arrested for, or convicted of any form of child abuse, neglect, or molestation? Wouldn't this have been covered in paragraph 3?
It would have been if it were you, in which case the information in the attachment would likely be repeated, but this also covers any other person living in your home.
If I had to check yes to this, how would I explain it away?
I don't know. It would depend on your specific circumstances, but it might be hard.
8. Let's see. I am not aware of any reports alleging any form of child abuse, neglect, or molestation made to any agency charged with protecting children. Isn't this almost the same as 7?
Similar, but 7 required an arrest. This just needs a report filed with CPS and doesn't require an arrest or even any action being taken by CPS, just a report being made to them.
I think I'm getting the hang of this. 9. Have you or has any other person living in your home habitually used any illegal substances or abused alcohol? No. 10. Have you or has any other person living in your home been charged with, arrested for, or convicted of a crime involving illegal substances or alcohol? Wouldn't this have been covered in 3?
It can, but it also includes everyone else living in your home and is specifically limited to crimes involving drugs and alcohol. In your case, the answer is yes, and so another attachment will be created to deal with your arrest for public drunkenness. Fortunately, it will be more or less the same as your attachment 3. A lot of people are surprised to find that they have to check yes to this because they had a DUI or a simple possession case years ago.
11. Do you or does any other person living in your home suffer from mental illness? I don't think so, although I don't know if the depression counts since I don't anticipate it'll hang around forever.
It's a little uncertain in your case, given the facts, but you can always err on the side of caution and check yes and provide an explanation. That way, it can't be claimed that you kept anything hidden.
12. Do you suffer from any physical disability that would impair my ability to perform the duties of guardian? No. 13. Do I have an adverse interest that the court may consider to be a risk to, or have an effect on, my ability to perform the duties of guardian? What does that mean?
Simply put, is there any reason that the court might think that there is some reason that you might be tempted to do something that would benefit you but would harm Lucy?
No.
Well, there you go then. This question really is designed for guardianships of the estate, so it doesn't pop up too often in guardianships of the person. 14. Were you ever appointed as a guardian, conservator, executor, or fiduciary in another proceeding?
What's that?
The most common reason you might respond that you have is that you were ever appointed a guardian before by a court, or were made by a court into the administrator or executor of an estate after someone died.
My mother's will named me her executor, but she didn't have any property to be divided, so it never went to probate. Does that count?
No, it would only count if you petitioned the court and were named the executor or administrator.
Okay, so no to 14.
Just to save you some time, 15 asks if you were ever removed as an administrator or executor. In your case, since you have never been appointed one, you were never removed as one. As to 16, The answer is I am not, because if you were a private professional fiduciary, you would know how these forms are completed, as you would have filled them out many times. 17 is also I am not for the same reasons. 18 is I am not because you are not filling this guardianship form out on behalf of a corporation.
So 16, 17, and 18 are all I am not.
Correct. Finally, 19 asks if you have filed for bankruptcy protection in the last 10 years.
I have not filed for bankruptcy in the last 10 years.
There you go. The only thing left is filling out Lucy's name, school name, home phone number, and school telephone number. Of course, since Lucy's not old enough for the school information, I'm just going to write none.
What do I do with 21 and 22?
You'd leave them blank. If you were seeking guardianship of more than one child, you'd use those additional spaces for them. Don't forget to date at the bottom, print your name and sign before you make your copies and file, being sure to include any attachments at the end. Finally, although this is the end of the statewide screening form, Sacramento has its own local form that you need to fill out.
Is that the confidential guardian screening form additional page?
Yes, it's pretty self-explanatory. You know your name, your employer.
But I'm retired.
So we'll write retired in line 2 for your employer. Know who your spouse is?
Of course.
So we'll circle spouse in number 3 and write your spouse's name. If you had a partner, we would circle partner instead. And if none, we'd just write none, just to let the person reading the form know you didn't skip over the question.
Right, and write none if I didn't have a spouse or partner. I think I get it. 4 is just a list of people living in the household with me, their birthday, and how they're related to me. Finally, Lucy's mother's name, address, telephone number, and date of birth, and the same for her father. What do we do about her father, since he's in jail?
We use the jail address if this is where he's going to continue to be, but if he were just in for a couple of days, we'd use his home address. We're in the home stretch, but the next form might take a little while, so this is a good time for a short break. Since you have the contact information for Lucy's other grandparents, now's a good chance for you to give them a call to see if they know anything about whether Lucy has any Native American ancestry.
Sounds like a plan. Meet you back here in 10 minutes?
See you then. Were you able to get a hold of them?
Yes, and they were able to answer my questions, so I think I'm ready to move on. The next form in the packet is the Declaration under Uniform Child Custody Jurisdiction and Enforcement Act. That's a mouthful.
That's why most people call it the UCCJEA. The UCCJEA is a law that has been adopted by every U.S. state and territory except for Massachusetts and Puerto Rico. It provides a standardized way for the different states to determine which state or states have the authority to issue custody orders for children. The biggest factor in that determination is where the child or children have recently resided. The declaration under the UCCJEA creates a standard way of reporting this information to the court.
The top caption will have my name, address, and phone number like the previous forms.
Correct. Below the address of the court, the petitioner and the respondent box is ignored because it only applies to family law cases, and instead, the child, in this case Lucy's name, is written after guardianship of. Now, everyone seems to want to check the box after paragraph 2, that the address is confidential, but it almost certainly does not apply in this case. This box is used in family law cases where one party has alleged domestic violence against the other and the current address is not known by the other party. In paragraph 3, I am writing the number of children, in this case, 1.
Child's name. I assume that's Lucy's name? Place of birth. Do they need a full address?
No, just the city and state.
That's easy. That was right here in Sacramento.
Okay, I'll write that down. And I think you wrote down her birthday earlier, so I'll copy that over. And is it safe to assume that Lucy is still female?
Yes. So the next box is asking me for residential information for the last 5 years. Well, she's been living with me since October 15th when CPS dropped her off.
Okay, so that's what we'll put on the first residence line. So I'll write that in the date on the first box before the words to present, and your address. Then in the next box, since she's living with you, your name and address again, and then finally your relationship to her.
Then the previous addresses go below this?
Almost. The old version of the form used to say address, but the new version only requires the city and state. As a result, as long as the combination of city and state and the person that the child lives with stays the same, multiple residences can be combined onto a single line.
That's good because she and her mom moved through about 20 different houses in Sacramento last year. I don't even know the exact dates.
Well, you know the end date, October 15th, so that's what goes in the second date on the line below. The end date on the line always matches the start date on the line above. When about did all of this start happening?
About January of the same year.
Okay, I'll go ahead and fill this in. Do you know where her mother is now?
No, but I know she's homeless somewhere in Sacramento.
I'll go ahead and put that down. Before January, where was she?
The year before that, from February to January, she lived with me and her mother.
At your same address?
Yep.
Okay, let me just put that down. And before that?
She lived with her mother and father in Citrus Heights from birth.
Okay, easy enough. Let me just fill that in.
We just used all 4 lines. What if I couldn't fit all 5 years into those 4 lines?
You would just attach an additional page, label it Attachment 3C, and continue listing the same information on it for the additional residences until you reach 5 years, and then check box C at the bottom of the page. That isn't uncommon where parents and children move from city to city frequently. If you had another child you were seeking guardianship of, you would put the other child's address in the next box, and if the information for the addresses was the same, you could avoid repeating it by checking the box below the child's name that says residence information is the same. Now, if there were more than 2 children, the Judicial Council makes a form, GC 120A, that can be used to list additional children, which looks just like 3 more of the boxes on a page. If you list additional children, you'd just make sure to check box D at the end of the form.
On the second page of the form, the short title of the case is Guardianship of, followed by Lucy's name, right?
Exactly, just like the other forms. Now, the second page is used to identify if there are any other court cases involving the child. Do you know of any custody cases involving Lucy?
CPS placed her with me. Does that count?
Only if CPS filed a case with the court.
I guess not. Well, now that I think of it, when Lucy was first born, her parents had a court in the case to add her father's name to her birth certificate. It was something like an UP case or something like that.
A UPA case, also called a Uniform Parentage Act or paternity case. In this case, you would look up as much as you can, which wouldn't be much since these case types are confidential files. But we'll go ahead and check family and provide as much information as we can figure out. That was in Sacramento, right?
Yes.
Any other cases?
No.
Is there anyone else who is not involved in this case who claims to have custody or visitation rights?
Not that I know of.
In which case we'll check No in item 6 and leave the information in the boxes blank. Finally, we'll fill in your name and date so you can sign at the bottom when it's printed out.
There's another form that follows this in the packet, the Indian Child Inquiry Attachment, but it doesn't have a caption on it. What do we do with it?
In this case, a copy for each child would be attached to your declaration under the UCCJEA. Since your case only involves one child, you'll only need one. Name of the child. Easy enough. So you were telling me earlier that you were able to talk to the other grandparents to ask if Lucy had any Native American ancestry?
Yes, they said that she didn't.
So I'm going to indicate that the inquiry was made and that the child has no known Indian ancestry. If you had learned otherwise, you would have checked the appropriate boxes to show what you learned. The grandparents that you spoke to earlier, were those the ones that you listed on the child information attachment?
Yes.
You talked with them for a while. Did they say anything else?
I learned some stuff about their family I hadn't heard before. Lucy's grandmother is from Russia, so there's no native ancestry on that side of the family. Her grandfather's family is from Ecuador, so while he has native ancestry from there, it's not with any of the tribes recognized by the federal government.
Okay, so we'll write Lucy's name in paragraph 1, check that the inquiry was made, and then check paragraph F to indicate that she has no known Indian ancestry. Obviously, if you had found otherwise, you would check the appropriate boxes and fill out the appropriate blanks to indicate what you had learned. Lastly, in paragraph 2, we are leaving this blank because this is not a delinquency proceeding, and then dating and printing your name.
It looks like we're down to 2 more forms.
Yes, the order appointing guardian and the letters of guardianship. The top caption is the same as the previous forms, but has been recently revised to make it a little more self-explanatory. Since you are self-represented, I'm skipping over the line that says firm name and leaving it blank. If you had an attorney, your attorney's information would be at the top of this, and the name of his or her law firm would be in the line that said firm name. Also, I'm checking the box that says person and writing in Lucy's name. With the newest version of this form, the option to use the order for multiple children was eliminated, so presumably a different order would be created for each child. But in this case, you only have one, so we only need one copy of this form. Almost everything on this form is to be completed by the court, but there are a few things you can fill out. In 1B, the box for department can be checked, and for Sacramento, it's a safe bet to write in 129. The top caption on page 2 can be completed with the name of the minor, and in paragraph 8A, the checkbox is checked, and the name or names of the guardian is written in, along with their address and telephone number, followed by the name of the child, so that it reads as a complete paragraph identifying that you are being appointed guardian of the person of the minor, Lucy in this case. Then 10 can be checked because there is no bond for a guardianship of the person. The top caption on the 3rd page can be completed, and then you're done.
Anything else?
The court fills out the rest of the boxes when the orders are made, so we'll move on to the last form.
The last one is the letters of guardianship. Is this the one you described earlier, that I don't sign until after the guardianship is ordered?
Yes. One set of letters is prepared for each child and guardian combination, as the form isn't really designed to handle more than one person signing it or more than one minor. In your case, of course, you only need one since there is only you and Lucy. The top caption is filled out exactly the same way as it was filled out for the orders, with the firm name being left blank. Then, below the top caption, the first checkbox in paragraph 1 is checked, and the name of the proposed guardian, in this case you, is written in the first blank, the box for person is checked, and then the name of the minor is written in the next blank. Paragraph 5 is the date the guardianship ends automatically, which will be the minor's 18th birthday, so Lucy's 18th birthday, so let me go ahead and write that in here. In paragraph 6, there are likely 0 pages attached, so that can be written in, and with that, the first side is finished. I'm not dating and signing because that information is completed by the clerk. On the second page, at the top of the page, I am writing Lucy's name, and then in the center of the page, under affirmation, I am leaving the date blank as it is not yet known, but I can fill in Sacramento, California for the place, and print the proposed guardian's name, in this case you. You won't date or sign this until after the court issues the orders and you are in front of the filing clerk after your hearing, at which point the remaining information will be completed.
Is that it?
That's it. Let's get this printed out so you can proofread it, and then we'll talk about copying and filing.